Well, Madam President, I appreciate the hard work done by my colleague from North Dakota and his commitment as chairman of the Indian Affairs Committee in trying to come to a solution in the Cobell settlement. He is absolutely right. We still need to work on some policy issues as well as some issues in terms of how this will be paid for. He and I both agree that we need to settle the Cobell lawsuit. There's been much rhetoric. We both agree that we need to settle the Cobell lawsuit. Now, at the President's insistence and the House and the Senate majority, they have repeatedly tried to get this bill enacted outside the regular process. This settlement has been inserted into various bills over the past several months that have absolutely nothing to do with American Indian issues. And you ask yourself why? Well, perhaps folks wanted to avoid some scrutiny by Congress, by the press, and most of all, by those who have been most affected, the stakeholders. Madam President, 2 weeks ago, I came to the floor, offered an amendment to legislation that addressed some of the more egregious problems with the settlement. Now, I'm talking policy as well as pay-for issues. The majority leader dismissed my amendment, and he called it the Beat Up the Lawyers Amendment. Well, Madam President, he called it that because one of the provisions in the amendment establishes a $50 million cap on pre-settlement attorney's fees. $50 million. The settlement says it should be between $50 million and $100 million. My amendment said, let's keep it at that lower figure. Only in Washington, D.C. would anyone ever call a $50 million cap on attorney's fees, $50 million of attorney's fees, as beating up the lawyers. Well, because attorney's fees were capped at $50 million, the majority leader objected to both the Cobell and the Pigford settlements. Mr. President, there was and still is a good reason for that cap. Every member of this body should read a couple of op-eds on this Cobell settlement. One was in the August 1st edition of The Hill, the other in today, August 5th edition. The August 1st Cobell settlement, worth doing right together. The one today, unconscionable Cobell. So I'd ask, Mr. President, that both of these articles be included in the congressional record.
Without objection, so ordered.
Thank you very much, Mr. President. So there are issues of policy dealing with transparency, dealing with production of records by the attorneys who were involved in this. When you read one of these editorials, the one in today's Hill, Unconscionable Cobell, written by a law professor at the University of Wisconsin-Madison, number of published court opinions in the case, 80 plus. Amount awarded to plaintiffs by the courts at present, 0. Amount to attorneys under the settlement, $100 million. Amount to each account holder under the settlement, we're talking about now those who've been affected by this, $1,000. What an incredible disparity. Well, if we're all to take the time to take a look through these two editorials, the changes to the settlement that I have been proposing would not only seem reasonable, they would be absolutely necessary. They point out several real problems with the settlement, including the way the attorney's fees are handled. I am continuing to work with my colleagues on dealing with that. These are the blunt facts. So I agree with my colleague from North Dakota. The problems with the Cobell settlement are by no means insurmountable. They can and they must be resolved. So, in fact, I don't think it would be difficult to resolve the differences that we have regarding the Cobell settlement. We would sit down and we plan to do that, to discuss the issues directly. I think we can get beyond this impasse, and that is what I am committed to do. Thank you, Mr. President. I yield the floor.